All right, why don't we get started? My name is Tim Sandefur. I'm the Vice President for Litigation here at the Goldwater Institute. I'm joined by my colleague, John Riches, and we're going to talk a little bit about some of the Supreme Court decisions from this last term. Before we get started in that, a little bit of housekeeping here. First, remember that you can ask us questions on our thoughts on these cases by putting your questions into the Q&A box online there in front of you, and John will monitor that box and give us some questions as we proceed. Also remember that our presentation today does provide CLE credit where applicable in your jurisdiction, so please check your rules and give us an email if you have any questions about that, and we're happy to provide you with the certification where required. Remember that the Goldwater Institute's main website, goldwaterinstitute.org, and our blog, which is In Defense of Liberty, indefenseofliberty.blog. We cover all the work that we're doing in courts and legislatures around the country to try and vindicate liberty for all Americans. And remember also that we can only do the work that we do thanks to support from people like you who agree with the kind of stuff that we're doing to defend individual freedom and send us some money to keep on doing that. You can find out more about how to donate to the Goldwater Institute at our website and how to contribute to our work. Also consider, if you're a practicing attorney, consider joining our American Freedom Network, which is our group of attorneys who want to help us out pro bono on cases that we're working on, which I guarantee you will be some of the most interesting cases that you will ever participate in. So we want to get started now to talk about some of the interesting cases that were decided. And I'm going to turn it over to John to talk about Cedar Point Nursery.
All right. Thanks, Tim. So Cedar Point Nursery versus Hasid involves two issues, which we always like talking about here at Goldwater: private property rights and labor unions. This case is a case out of California where the Supreme Court held that a California regulation that required agricultural businesses to allow union organizers access to their property violated the Fifth Amendment's prohibition against taking private property without just compensation. So the facts were pretty simple. Two agricultural companies, a grower and a shipper, challenged a regulation that had been on the books for 50 years, a state regulation. That regulation allowed union organizers to enter agricultural land for up to 3 hours a day over a 30-day period for a total of 120 days per year. The landowners sued. They argued that the regulation allowed the government to take their private property without just compensation. The Fifth Amendment prohibits the taking of private property for public use unless the government pays just compensation. Now, in response to the lawsuit, the California board that imposed the regulation argued that it didn't constitute a per se taking, but really just restricted the landowner's ability to use their property. So it should be tested under the more permissive Penn Central standard. And so that sort of asks, is what's the economic impact of the regulation? Is there investment-backed expectations, et cetera, et cetera? Importantly, the Supreme Court declined to apply Penn Central, finding instead that the access regulation physically appropriated the property and denied the owners, quote, the right to exclude, which is a fundamental element of the property right. The court also rejected the state's argument that the access regulation was not a taking because it was only temporary. The state said, hey, no, this is only 3 hours a day. It's only 120 days out of 365. It's just a temporary taking. It's not a permanent one. And the court rejected that as well and said the duration is only relevant when we're talking about the amount of compensation that's due. So court struck down the 50-year-old regulation, big win for private property rights, big loss for big labor. A couple of things that occurred to me, Tim, when I was reading it, particularly in that last point, that the duration only related to the compensation. What would happen if the state did offer compensation to allow the union organizers onto the property?
It kind of brings to mind the Loretto case where one of the per se takings cases. In that case, it was a single cable, right? The people who who owned apartment buildings in New York were required to install cable, which meant they were required to install a 1-inch cable on their property. And the court said that was a taking because it's a permanent physical occupation. And when the case went back to trial, the property owners were awarded $1 in damages. You know, another thing actually on this temporary thing that it brings to mind is a case more than 20 years ago now called Tahoe Regional Planning Agency, where the area around Lake Tahoe, is governed by a special government unit that's a compact between Nevada and California. And they had prohibited all development in a series of what they called temporary building moratoria, except they were just being indefinitely renewed, one after another. And the Supreme Court said no taking, which is ridiculous, I think, because you have cases that say, like the Lutheran Church case, that say a temporary taking is a taking. And of course, we know that a total taking is a taking from cases like Loretto. So it should be the case that a temporary total taking is a taking. And then in San Remo Hotel, in the Tahoe Regional Planning Agency case, the court says, no taking because it's just temporary. Totally irrational. And I don't think you'd get that kind of result with today's court. I think that's a legacy of the sort of post-New Deal court that was very hostile to private property rights. And, one hopes that that's changing now.
One other thing is I was thinking about application of the case. Do you think something like this could be applied to, for example, the recent eviction moratorium, where you're preventing landlords the right to exclude non-paying tenants or tenants who are otherwise in breach?
Yeah, it would take, I was going to say would take litigation, but we've already had tons of litigation on this issue over the past year and a half, and the courts have uniformly said that this is illegal, these eviction moratoria, and nevertheless, the Biden administration recently announced that it's going to do so anyway. And in fact, President Biden himself said that he acknowledges that there is really no legal argument here. They're just going to do it anyway. Complete lawlessness by this administration, which cannot be condemned in strong enough terms. Nevertheless, that brings to mind a case called Yee versus City of Escondido, which was a case about so-called mobile homes. Of course, they're not really mobile, but in a mobile home situation, the resident doesn't own the underlying land. They own the structure, but not the underlying land. And that was a case about whether the landowner's rights were violated when the state said that they can't evict people. And the court said, the Supreme Court, if I remember right, Justice O'Connor said, no, it's okay, because they're not taking away your right to exclude, because you have the right to decide whether to let somebody onto your property to begin with. We're just taking away your right to throw them off your property, which of course is illogical. And again, I hope is one of those cases that if it were to come before the court today, I think it would have a different outcome, but
It seems to me the court's trending very positively for private property protections in a way it hasn't for quite a long time.
Yeah, well, it would be hard to imagine the court getting much worse when it comes to private property, comparing it to cases like Kelo and so forth.
Right. Why don't we transition over to the next case? This is California versus Texas. Can you imagine two better adversaries?
Really, that's a good title of a book right there. This is the third of what the court has called its ACA trilogy. That's the Affordable Care Act or Obamacare. And this is the latest round of litigation over it. Now, you will all remember that more than a decade ago now, the Supreme Court took up this issue about whether the government can force you to purchase health insurance through the individual mandate provision of Obamacare. That individual mandate said you have to buy insurance, and if you don't, you face the penalty, a financial penalty. And then the litigation was over whether that penalty is a penalty or whether it's a tax. And the Supreme Court, I think rather disingenuously, interpreted it as being a tax instead of a penalty and said, therefore, it's constitutional. Well, now Congress comes along and zeroes out the penalty, says your penalty is $0. Well, the reason that's significant is because the last time around, the litigation was over the Commerce Clause, whether the Commerce Clause allows Congress to force you to buy something or not. And what the Supreme Court said was no, Congress does not have the power to force you to buy things under the Commerce Clause. It only has the power to tax you. Well, by zeroing out the individual mandate and saying there's no revenue generation there, now the question is, assuming it's no longer in function a tax, it's a nothing, it's a nullity, then what about its constitutionality now? Like there were the one leg it had to stand on in terms of constitutionality has been knocked out from underneath it. So the question was, now that it's zero, is it constitutional? That goes up to the Supreme Court. The Supreme Court there says there's no standing, so they're not going to resolve this question. Now, the standing issue, that was a 7-2 decision. And honestly, I think it's probably right in terms of the standing issue, aside from the constitutional question about Obamacare and so forth, which I think it is unconstitutional. But standing is a question about whether you have the right to sue. Standing, it all, can sound complicated when lawyers talk about it, but it boils down to who are you to complain? That's what standing means. There were two groups of people suing here, individual citizens and states. The court said individual citizens don't have standing. They don't have any grounds to complain because they're not being punished. They're not being penalized. They don't face this $0 penalty because that's nothing, therefore no standing. The states had a slightly stronger argument. They had two arguments. They said, well, we are required to spend money and do certain things under the Obamacare statute. And those things that we're required to do are basically triggered by the individual mandate. So our greater burdens are affected here. So that therefore it's an imposition on us. And the court said, no, that's not right. The states have no standing because without the penalty, the states, there's no showing rather that without the penalty, the states bear more cost than the otherwise would have. And the other costs that they do bear result from other things other than the individual mandate. Now, that was, as I said, a 7-2 decision. Justices Alito and Gorsuch, they dissented from that. And they said the fact that Obamacare is basically a single inseverable unit, it's a single thing. The mandate goes along with all the other requirements and can't be separated. Therefore, the states have standing. If they have the right to sue over one thing, then they have the right to sue over another thing. It's a very sophisticated argument. It's pretty persuasive. Justice Thomas writes a separate opinion where he rejects that argument. He says, this is an interesting theory. We've never really addressed it before. I'm not comfortable going that far. Even if he had, of course, it would still have been a 6-3 decision against the plaintiff. So it wouldn't have really got anybody anywhere. But it's an interesting thing, for those of us who are interested in legal philosophy and constitutional obscurity, to ask what, this inseverability issue in standing. And it does seem pretty dishonest that Obamacare's proponents started out by saying this thing is it all has to go together. You can't just have half of this law, you have to have the whole thing. And now all of a sudden they turn around and say, no, now that we've gotten rid of one, the rest of it can remain. That seems pretty legally dubious.
This is the first time, and I'm sure it's not the first time, but the first time in recent memory I can remember where a state's been denied standing. Is that unusual?
It is interesting that states have been given more authority to sue in the recent decades, really, than previously they have been. So in a very famous incident in Massachusetts versus EPA, the states were given standing to sue the federal agency for not regulating. Now, normally, states are not allowed to sue the federal government for things that fall within the federal ambit. The theory being that what they call parens patriae standing, that is, who represents the citizen, the state or the feds? Well, it's the feds when it comes to an issue that's relates to your federal citizenship. And obviously, since the New Deal anyway, that's been basically everything. So that means that the states generally can't sue unless there's something really distinctively state-oriented. And that's stuff like, can the state sue over pollution, right? And that's where EPA came from. States also sued over Obamacare the first time around in several lawsuits. And there was a lot of argument over whether they had the standing to do that. In Arizona, for example, Arizona has laws that prohibits the state from participating in a program that forces people to do stuff like the Obamacare individual mandate. So that intrudes on the state's sovereign interests. And the question was whether that gives them standing to sue the federal government over the constitutionality of Obamacare. And states were allowed to sue in that case. Of course, everybody, the federal government won that case. But yeah, it does seem like there's been a trend toward expanding states' authority to sue the federal government, and this might indicate something of a retreat from that. The question is where the new justices stand on this.
Is this it for Obamacare? Third time's the charm? Any other challenges coming?
Well, I think we will always see some form of challenge going forward one way or the other until this whole thing is put to bed one way or the other. I mean, people are going to run into contract disputes, tax disputes, healthcare disputes that will inevitably end up in the courts, and they will inevitably involve some form or other of challenge to the constitutionality of Obamacare or how it's implemented and stuff. And really, Obamacare remains a half-baked pie, and at least as long as it remains half-baked, and believe me, half-baked is the right term for it, then this question is not going to be resolved.
Yeah, I agree with you. Just a reminder, if you have questions, type them in the Q&A section. There was one from the last case from Cedar Point. What was the reason for wanting access to the land by the unions? So they could recruit new members. They like to, of course, come into employers, whether that's private or public, and talk to the workers so they can try and recruit.
It's basically an easement, right? That was a situation where the union is given an easement across people's land.
Yeah, exactly. All right,
let's talk about, this is a case that is near and dear to your heart, because you did a related case some time ago called NAACP versus Alston.
Yeah, an NCAA, although it would have been more interesting had the NAACP been the.
Did I say that? I do that every time.
I used to do that in the De La Haye case.
Not being a sports guy, unlike John, I at least have an excuse for screwing that up every time.
The NCAA, the body that regulates college athletics. So this is an interesting one, and it's getting a lot of play in legislatures and in the courts. Here, this was a unanimous decision from the Supreme Court that said that the NCAA cannot restrict member schools from providing education-related benefits, things like post-graduation scholarships or laptops, things like that, to student athletes. The NCAA could not do that under federal antitrust laws. So antitrust is not an area normally where Goldwater would litigate, certainly not an area we would litigate, even an area where we would be focused on much. But this case overlaps with some of our other First Amendment work, like Tim mentioned, specifically involving a student athlete's use of his or her own name, image, and likeness. And we'll talk about that case in a second. But what happened in this one at the Supreme Court? So under NCAA rules, colleges are allowed to provide student athletes scholarships, textbooks, room and board, but that's about it in exchange for playing at the school. In this case, the plaintiff athletes and former athletes contended that those rules violated federal antitrust laws because it barred athletes from receiving fair market compensation for their labor. In a unanimous decision authored by Justice Gorsuch, the court agreed. Gorsuch said that he started by asking what legal test should apply, and this was an important component of it. And the court applied a rule of reason test. So under this test, the NCAA had to supply a legally valid pro-competitive justification for its compensation rules. And they really couldn't provide a pro-competitive justification because their rules were at bottom anti-competitive. The NCAA had asked for a less stringent test. They essentially argued that because its rules define amateurism in college athletics, they shouldn't be subject to antitrust scrutiny. So they sort of said, the whole product of college sports is amateurism. It's this notion that people like college sports because the athletes aren't paid, which is kind of a remarkable proposition. And Kavanaugh issued a really wonderful concurrence in this, where he not only agreed that the restrictions on education-related benefits alone violated antitrust laws, but that probably all of the NCAA's remaining restrictions on compensation also probably violate antitrust laws. I want to read just a one paragraph from it because I think it's just really well written and funny, frankly. So Kavanaugh says in concurrence that the NCAA couches its arguments for not paying student athletes in innocuous labels, but the labels cannot disguise the reality. The NCAA's business models would be flatly illegal in almost any other industry in America. All of the restaurants in a region cannot come together to cut cooks' wages on the theory that customers prefer to eat food from low-paid cooks. Law firms cannot conspire to cabin lawyers' salaries in the name of providing legal services out of, quote, a love of the law. Hospitals cannot agree to cap nurses' income in order to create a purer form of helping the sick. News organizations cannot join forces to curtail pay to reporters to preserve a tradition of public-minded journalism, and movie studios cannot collude to slash benefits to camera crews to kindle, quote, a spirit of amateurism in Hollywood, price fixing labor is price fixing labor. So he is certainly not convinced that any of the NCAA's rules that remain on the books are themselves lawful. They probably all, according to Justice Kavanaugh, violate federal antitrust laws. But setting aside the antitrust question, this one is of interest to us because we litigated, and really we're one of the first groups to litigate in at least the last decade or so, this question of whether the NCAA could also restrict a student athlete's use of his or her own name, image, and likeness. So not only do NCAA rules prohibit schools from paying athletes, they also prohibit athletes from going out and using their own name, using their own pictures or film or whatever to make compensation from other third parties. So we represented a guy named Donald De La Haye. He was a kicker on UCF's football team, and he made YouTube videos. He'd basically done it his whole life since high school, where he would do things like trick shots and parodies of different football players. And his school, University of Central Florida, public school, so this is why it implicates the First Amendment, came in and said, because you're putting your videos on YouTube and because you have so many followers on YouTube, at this point he had about 100,000 followers, YouTube has offered to compensate you for your videos. You got to take them all down or we're going to kick you out of school and pull your scholarship. And he said, nope, I'm not. And by the way they defined athletic related videos included a video of him like throwing a football on the beach with his girlfriend. So Donald declined to take down his videos. The school kicked him out, pulled his scholarship, and he ended up sleeping on his buddy's couch for several days because that was the only way he paid for school. So we sued. We brought a case against the university, not the NCAA, because the university is the one that pulled his scholarship, arguing that they could not satisfy the very high level of scrutiny subject to First Amendment cases by pulling a student's scholarship, kicking him off the team merely because that student participated in truthful, non-misleading communications. And ultimately, we won an early victory on a motion to dismiss. The case settled for reasons that aren't totally relevant to the First Amendment claim. But interestingly, I think this case was part of a larger puzzle that started the pieces of some of these NCAA rules getting more scrutiny. And that's kind of what's really nice about public interest litigation. Even if you don't get a full win or a clean win in the courts, it can set you up for success down the road for public policy victories, rule changes. Shortly after the case, the state of California essentially said they're not going to allow any California state universities to follow the NCAA's rules on name, image, and likeness. And ultimately, just last year, the NCAA changed its rule and now allows students to receive compensation for name, image, and likeness. And lo and behold, the sky has not fallen, and kids can go and work with a pizza company and get a few dollars from using their social media accounts. And turns out the world doesn't end.
It does seem counterintuitive that a student could start any other kind of business, and you could. There's a lot of people who have YouTube shows that make money, and their shows, I don't know, they're puppet shows for kids or whatever it might be that the student puts on the internet and makes money from. That's okay, but he can't kick a football. And boy, I saw some of De La Haye's videos. I remember he was very talented. It was amazing what he could do with hit these trick shots into people's windows and stuff. It's amazing.
Yeah, I think about this, the application of this rule in any other context. I think if a university told a journalism student that they couldn't go out and write a freelance article for a local newspaper and be paid for it. They couldn't use their name for the skills that the university is purportedly teaching these students just to receive compensation. Yeah. It's pretty outrageous.
Which is something that in our internet world is increasingly likely. Students could have a Substack account, for instance, where they're paid for writing about things like that. In fact, this kind of touches on our next case, which is the case about a student. This was a high school student who off campus, what were the limits on her free speech rights? This is a case called Mahanoy. And this is, I assume that's how it's pronounced. Certainly the student annoyed a number of people with what she did. She was a member of the cheerleading squad. And for one reason or another, she got upset about the cheerleading squad and posted on Instagram some comments deprecating the school and the cheerleading squad, including obscenities, and then she was punished for this. And the question is whether that violates her First Amendment rights, since it was a government school. And this touches on an old case that's really near and dear to my heart called Tinker versus Des Moines School District, 1968 case that is actually the case that got me into constitutional law when I was a student in school, and I learned about this case. It's what really drew me to be interested in the Constitution in the first place. And in Tinker, it was some students who decided to protest the Vietnam War by wearing black armbands with peace symbols on them to school. Now, this was at a time when the peace symbol was still a very controversial symbol. It has become kind of, it's ordinary jewelry today, but in 1968, it was still kind of controversial. And these students were punished for wearing these armbands in class. The Supreme Court said that violated their First Amendment rights. Now, the court said a student does not give up his First Amendment rights at the schoolyard gate. But the court also said that schools can impose certain disciplinary standards, and if a student's speech is disruptive to the classroom environment, the school can limit that speech. So the question was, in this case, what about off-campus speech? As Justice Alito pointed out in his separate opinion in this case, this is the first case to really address that question. You might remember that there was the so-called Bong Hits for Jesus case a few years ago about a student who off campus was holding up a sign that said Bong Hits for Jesus, whatever that means. He's a teenager, it doesn't mean anything. Anyway, he was punished for that. The Supreme Court said that that was not truly off-campus speech because there was stuff going on at the school at the time. This was the first time the court has really talked about off-campus speech and how that relates to the Tinker case. And the Supreme Court said you can't punish the cheerleader for this. They gave 3 reasons. First, the school does not stand in loco parentis for a student off campus. When a student is on campus, the school stands more or less in the shoes of the parent when protecting the student and their interests, but not for off-campus speech. Number 2, there was no evidence here that there were on-campus disruptions caused by the off-campus speech. That part I'll get back to in a second, because I think that's a little dubious. And then number 3, there was no evidence of a decline in team morale as a result of what the student did. So that lessened the school's interest in policing her speech. So the school cannot censor based on a mere allegation of a possibility of future harm. Now, that's a good thing. That should be the rule, that the school can't censor students just because they fear that maybe the student's speech might cause disruption at some point in the future. They have to have actual evidence of disruption of the classroom before they can censor a student. But this question, as I said, number 2, this issue about any evidence of on-campus disruption caused by the off-campus speech, that seems pretty fuzzy to me. How do you exactly prove that? How do you prevent a really bad on-campus situation from speech off campus? Say the student says something off campus on Friday that the administrators know is going to cause a big problem in the classroom on Monday morning. Why can the school not act then? Now, I think the court would answer and say they can if they have real evidence for that, then they could meet that standard. But I foresee that being a real problem in today's pervasively internet world. You know how kids are. Somebody says something on Facebook, that becomes what they gossip about at school the next morning. And that sort of thing can snowball, and it can be very hard to police. So I think this is a case that fails to set out a clear standard. In fact, the court specifically praises itself. It says, quote, "We do not put out a broad, highly general First Amendment rule here." Well, that is what the court's supposed to be doing, right? Setting out highly general rules, and they fail to do that. Justice Alito, this is an 8-1 decision, by the way. Justice Alito and Gorsuch concur, and they write a very interesting, very thoughtful examination of this issue. Why is it that the government can censor a student at a public school in a way that they can't censor other kids? And the court, the 2 of them say it's basically kind of a form of consent. The parent is kind of consenting to let the school censor the student in order to accomplish its mission. They acknowledge you're not really consenting since it's compulsory school, but they're saying that it's kind of like the student says, okay, I'm going to put this student under this teacher's tutelage, and that gives them a certain limited authority. But of course, it doesn't control for what happens off campus in most cases. It's a very thoughtful decision worth looking at. Justice Thomas writes a dissent because he takes a very extreme view on these issues. He says that students have no First Amendment rights, period. I think that's clearly wrong. The basis for his saying that reaches back to stuff like the laws of the Puritans, which I don't think have any relationship to what the First Amendment means, but that's sort of a debate for another day. So it's a very interesting issue, this question about off-campus speech. By the way, there's another factor to this. Although this case involved free student speech in Tinker versus Des Moines School District, we can see that on the horizon, there's going to be a huge problem about off-job, off-work speech by public employees. At what point can the government control the speech that takes place on a Facebook page by a government employee? This has already been the subject, obviously, of much litigation, and it's only going to become worse as we live lives half on the internet, half off the internet.
Yeah, I was pretty dissatisfied ultimately with the outcome here. It requires a highly fact-intensive thing, and you never really know which way it's going to come out. I think there was an opportunity to kind of set down a clear.
I agree with that. There is one thing that I think is a benefit, which is it does make this clear that you can't censor the student just on a general allegation that it might cause harm in the future. Of course, this was central to our own lawsuit about the student who took a large plaster elephant painted with the name Trump on it right before the election, put it in the back of his pickup truck, drove it to school. This is in Florida, drove it to school to support his candidate for the presidency, and was punished by the school. They took away his parking pass for this because it might cause disruption at some point in the future. We went to court, won that case. Important victory, I think. But that part of this case is satisfactory. But to be frank, it's one of these Justice Breyer opinions where it's like balancing this versus that, and this factor is relevant. Nobody knows what that's going to mean in the long run.
Yep. Let's see here. We got a couple questions. We might save one or two of them for at the end because they weren't asking about the specific case. But one here, we're asked, what about the work? The student who stays up, studies late, works in the research lab, writes proposals. Should they be compensated for their contribution? Isn't it just as valuable as that of a student athlete? Yes, of course. Any student should be compensated across the board for any services that are rendered, so long as it's voluntary and there's an arm's length transaction, and that's what both sides, agree is appropriate. What was obviously strange about the context with student athletes, there's a per se prohibition that public schools are required to enforce, and that's a problem. I mean, why just them? If there's value that's being added to the university, whether it's football, basketball, or research assistants, then there should be no per se rules against compensating for that value. All right. What do we got next, Tim?
We got next your case of AFP versus Bonta. Well, we both worked on this case, but.
Oh, yeah. So this is perhaps one of the most consequential, at least in our views, decisions from last term. So here, the court held that the California Attorney General's requirement, and by the way, the Attorney General in California at the time this requirement was imposed was Kamala Harris, that nonprofit organizations have to disclose the identities of their major donors to that office violates the First Amendment. So the facts were this. The California Attorney General regulates charities within that state. So they have to determine whether there's any fraud or things like that for all nonprofit organizations that are registered in the state. Now, when Kamala Harris was Attorney General, she claimed that it was part of her regulatory responsibilities to request, to demand the names and other identifying information of nonprofit donors that are reported on what's called a Schedule B. So every 501c3 nonprofit organization has to submit a Schedule B form to the IRS, which lists the name and other identifying information of major donors to the organization. So she said, hey, we need this information because it's going to help us regulate charities effectively. She was sued by Americans for Prosperity and Thomas More Law Center, and the court struck down that requirement. The court observed that even though all 60,000 nonprofits were required to submit this form, the state had never relied on any information in that form to initiate any actual investigation against a charity. And so the court basically said, ultimately, look, this justification that it's just administratively convenient to receive this information is not a compelling justification under the First Amendment. And the court wrote that, it was quoting another case, but the prime objective of the First Amendment is not efficiency, right? It's the protection of free expression. Interestingly, the court also rebuked the state of California for its argument that the information would remain confidential. So throughout the litigation, the Attorney General said, look, there's really no harm that's going to come from us demanding this information because we promise we'll keep it private. Well, it turns out that evidence that was presented at trial in the district court and the lower court showed that the California Attorney General had mistakenly released thousands of these supposedly private forms that they were supposedly supposed to keep private to the public on the internet. They had just produced them on the internet. So the court was displeased with that. And I think obviously the import of this decision is that in an age of doxing, physical threats, stalking, for people who express positions on policy matters, that threat is real. It's getting worse. And when governments try and demand private information from private parties based on their associational activities, their free expression activities, it creates a real risk of harm to people that might want to remain anonymous. And frankly, there's all sorts of very good reasons for anonymity going back to our founding. One thing I thought was interesting here, I thought this, the trial, usually a lot of these cases that end up in the Supreme Court are questions of law, so they're not really heavy fact intensive where long trials don't need to take place. But the trial here, which is somewhat unusual in a lot of public interest cases, was really pretty crucial because it allowed the proponents, AFP and Thomas More, to basically rebut the state's sort of absurd assertions through evidence. And I think that the Supreme Court looked back at that record and relied on that in a pretty important way as first decision.
Yeah, there's no question about that, because remember that there was another case before this case where our friends at the Institute for Free Speech, which at that time was called the Center for Competitive Politics, brought their own lawsuit arguing that this law, that this demand was facially unconstitutional. And the Ninth Circuit dismissed that case. They were very unsympathetic to bringing that kind of facial claim. Meanwhile, this other lawsuit where the facts are being put forth in a trial, it was kind of a two-pronged strategy, so that when it got up to the Supreme Court, the court could say, well, here's the evidence, even though they ended up finding it facially unconstitutional, because the only interest that the state put forward was this efficiency interest, well, it makes our lives easier. Which incidentally is why I personally think this case is probably of limited impact going forward. What the court said was demanding this kind of information from an organization simply to serve a mere efficiency interest. That's an inadequate interest to justify demanding this much information. But how often is a politician going to say, Your Honor, we don't really need this information. It just makes our lives easier. They're not. The next time around, they're going to say, this is absolutely crucial. We use this information all the time. The world is going to be destroyed if we allow Republicans to donate money to groups they agree with, and that sort of thing. And so I don't think that in the long run, it's going to have much effect in that sense. Still, it's a very welcome recognition by the court that these disclosure requirements are a form of intimidation and harassment. They're politically motivated. And incidentally, it's worth adding that we at the Goldwater Institute received one of these demands from the state of California, which we declined to comply with. And it was 10 years, but we finally, our rights, along with everybody else's, were vindicated by the decision in this case. But you can see that the next time around, that kind of harassment, and incidentally, this harassment, as you mentioned, John, it's not a hypothetical. In California, particularly, the big example of this is the Proposition 8 campaign, the anti-same-sex marriage initiative, when the names and identifying information, that's addresses, phone numbers, employers, and when that information of supporters of the initiative was put on the internet, and people were making Google Maps of people's home addresses and basically encouraging vandalism and intimidation and harassment and violence against people who had donated to these political campaigns, which did happen. The Heritage Foundation put together a very helpful resource, a collection of stories, examples of this kind of harassment that went on. That's a real concern. And of course, we have our own lawsuit going on right now where we're representing the Rio Grande Foundation in New Mexico, challenging a similar donor disclosure requirement that says if an organization supports or opposes a ballot initiative, it has to turn over the names, addresses, phone numbers, and employment information of anybody who donated even a penny to the organization for that purpose. So even if I give Rio Grande $1 to oppose a sales tax in Santa Fe, New Mexico, which is what happened here, then my information has to be put on a publicly accessible government list that's up there forever, permanently on the internet. There's no way you can truly get rid of that information. And obviously that's going to chill the freedom of speech.
And I'd add to, this case was really a culmination of a lot of work for a lot of years. Many years ago, we did some early scholarship as these sorts of demands were coming or were growing in intensity. We put out several policy papers. We discussed the history of donor privacy, civil rights era, NAACP this time, versus Alabama, the decision where the state of Alabama essentially requested the member list of the NAACP local chapter. The NAACP declined. It went up to the U.S. Supreme Court, and the court said, look, you have an associational right to remain private in your associations.
Although, when you put it that way, that don't forget that the NAACP was put out of business in Alabama for years because of that demand, and before the Supreme Court finally issued that decision.
Yep. Yeah, and then of course we had some model legislation along these lines, where at the state level, the state legislatures have come in and said, no, look, there's a privacy interest in this information, and we're not going to have any state or local government be allowed to demand it from private citizens.
And this thing about efficiency, it's not like the Attorney General of California couldn't get this donor information if she needed it.
This is Attorney General.
Yeah, a subpoena would have worked, an audit. That was undisputed in the case. It was just, it makes our lives easier if you turn over this information, and then we'll put it on the internet. 1,800 examples of people's. Anyway, I was quite surprised that the state of California was willing to go so far for so long. This case has been pending for 10 years. This litigation was going on. So it's not just Kamala Harris, it was her successors were still willing to push this very extreme attitude about forcing disclosure, depriving people of their privacy rights. I just found that really remarkable.
Yep. Tim, why don't you round us out with our last case, and then we'll save a little time for some questions here. We got some in the box.
This is a case that everybody's interested in, who's interested in politics. This is Brnovich versus Democratic National Committee. This is the case about Arizona's rules for voting. It was a 6-3 decision upholding the Arizona statutes, which prohibited people from carrying ballots for other people, so-called ballot harvesting, and required people to vote at their precincts as opposed to other precincts. Now, this case, to be honest, I think this is not an easy case. I think although those restrictions are very reasonable, Justice Kagan wrote a dissenting opinion that I think raises some really interesting problems. And Justice Kagan, don't ever underestimate her, as no matter how far up political right you might be, Justice Kagan is a very smart attorney and a very capable writer, and she can write very persuasively. So she puts the liberals justice's case very strongly in this opinion. It's worth reading because she raises a lot of good points. Anyway, the court upholds these two requirements because there's no overt discriminatory purpose, no racially discriminatory purpose for requiring these things. And these requirements of voting in your precinct and no carrying of ballots like that were nothing more burdensome than, quote, the usual burdens of voting. Now that's a crucial sentence there. That's a crucial line in the opinion. Finally, the court says that the racial disparity that results from people having difficulty voting is very small. They said it's less than 1% of voters had any problem at all, and this is relatively minor. Justice Kagan, however, in her dissent, she says, yes, the disparity is small in absolute terms, but what difference should that make? If it's only 1% of voters who have a problem, that sounds like it's okay. But if that 1% of voters happens to be all of the voters of a certain racial minority, let's say your state only has 1% of the voters are Black, and they're the ones who constitute that 1% that have trouble voting, well, obviously that's a racial discriminatory problem, right? She says Arizona has vastly more disparity than other states. If you compare Arizona's disparity with those of other states, Arizona's is way out ahead. So that's an indication of a problem. And obviously Arizona is unusual in that a quarter of the entire state is reservation land, and a lot of Indian reservation land. And so a lot of people live in places that are very remote from their nearest post office, remote from their polling place, and they are going to have a disproportionately difficult time getting their votes counted under these rules. That's a pretty solid argument. But what the majority says in response to that is you're going to have some kind of disparity, some kind of impact, no matter what rules you have for voting. The fact that you have to punch a hole with a little stylus, that alone is going to be a difficulty for some fraction of the population out there. Any ordinary requirements of location, age, familiarity with the voting process, whatever it is, any rules you have whatsoever for the voting process are going to, by definition, exclude some people. So it comes down to a question of how severe a disparity does it have to be to trigger the problem, and here, to trigger our concerns. And here, these restrictions are no broader, as I said, no broader than the usual burdens of voting. That seems like a rational conclusion. There, as I said, both sides of this decision, I think, put their arguments very clearly and very persuasively. But the bottom line is that it's true, discrimination can be hidden in what appear to be non-discriminatory terms. But here you have a restriction that because it's similar to the burdens that a colorblind society would necessarily impose, they can't trigger our concerns about racial discrimination in voting.
And I suspect decisions like this, Voting Rights Act decisions, are going to be getting a lot more play as state legislatures move different, voting integrity and other issues through the process.
Yes, and these restrictions that were at issue in this case, I think, compared to some of the things that have been talked about, are the bottom line, the minimal restrictions. So you're going to see future cases that involve more complicated, potentially more difficulty in voting, right? The more stringent requirements, those cases have not yet, they're coming, they just haven't come yet.
Well, that rounds out our case discussion. We still got about 12, 15 minutes for some questions. So feel free to type them. We do have some here. So most relevant to the most recent case discussion, Justin Kagan's opinion claims to use textualist interpretation and cites Scalia. Was it a good example of textualism and of Scalia type analysis?
Which I assume you're talking about the voting case?
That's what it looks like.
Yeah. Well, I mean, I guess it's up to those who read the opinion to whether they're persuaded by it or not. But this question does raise what I think is a very interesting issue in terms of overall jurisprudence going forward. And particularly, you might say, what do you do with a problem like Gorsuch, right? So Justice Gorsuch, who I'll just say personally is becoming my very favorite justice on the bench today, Justice Gorsuch is not exactly the originalist that you might think he is. He's more of a textualist, meaning that he is more interested in the wording of the law than in its historical pedigree or its historical interpretations, which I personally think is probably a more plausible jurisprudential approach. But it does mean that he finds himself on the odds sometimes with, say, Justice Thomas, who takes the more originalist approach. And I think nowadays the most interesting Supreme Court opinions are those in which Thomas is on one side and Gorsuch is on the other. If you read them debating against each other, that's really legal argument at its finest. So it is true that Justice Kagan relies on Scalia for some of these textualist approaches. And I think that's kind of an indication of where the real fault line lies on the court nowadays. You don't really find the living constitutional argument being put forward by any of the justices nowadays, the way you did back in the 70s with people like William Douglas. Nowadays, the fight, I think, tends to be this textualist originalist divide. That doesn't exactly answer your question, but it's what I think is most interesting about this division.
Kagan herself said we're all textualists now, which was kind of interesting coming out of Kagan. Okay, we got a couple questions about some of our current litigation. Can you tell us the status of the Proposition 208 case in Arizona? Can you? So this is a case where we represented lawmakers and taxpayers in a challenge to the single largest tax increase in the state's history. It added a 3.5% surcharge on income earners above $250,000, representing an 80% tax increase for those taxpayers. Incidentally, it also happened to violate Arizona's constitution, which puts in place very clear limitations on the amount of money that can be expended every year on public education. And this simply blows those expenditure limitations out of the water. So we've been litigating this case since the early part of this year, and actually into the latter part of last year. And it is now briefed up entirely in a preliminary injunction posture before the Arizona Supreme Court. It has been argued. One of the attorneys we're working with on this, Dom Dre, argued it before the Arizona Supreme Court
in April.
And we are awaiting a decision. So that was a long way of saying we are still waiting. I would expect one to come sometime in the near future, but I would have said the same thing about 2 months ago. I think maybe the silver lining here is that even though it's up in a preliminary injunction posture, meaning usually that's just an early question in a case, but can be dispositive. I would think because the court is taking so much time to get its decision back, it will probably be dispositive one way or the other. I don't know if you agree.
I was thinking the same thing recently. I mean, that it's always risky to try and predict what the court's going to do. And, knock on wood, we're tempting fate by even talking about it. But that's my interpretation too. I don't think that they would take so long if they weren't going to issue a really thorough opinion.
Yeah, I think that's right. I got another question about a current case involving, this is near and dear to my heart, what's happening with Nicole, the Rhode Island mom being sued by the NEA. So this is a remarkable case where a mother in Rhode Island had an incoming kindergartner, and she requested public records from her school district about what the district was going to teach in the upcoming year. And she was stonewalled. Then she was sent fees, massive fee requests. We ended up representing her on a public records request, and the district said if we wanted to get a very discreet set of emails, it was going to cost Nicole $74,000 to provide them. And in the latest outrage in this story, the NEA, the National Education Association, sued Nicole, the mother, for requesting public records under the state's public records access laws. So pretty extraordinary when you have these laws that are intended to open up government, to make government transparent, to be turned around and weaponized against the public that they're supposed to protect, which is precisely what happened here. Of course, the NEA's lawsuit is a pure intimidation technique. They're trying to scare Nicole. They're trying to scare other mothers like her. It's not going to work. And
for what? For trying to find out what's being taught to her child in the public school classrooms that her tax dollars pay for. It's truly outrageous.
It's really, it's just really remarkable. It's one of these cases where you really can't make this up type of case. Is this really happening? But we are defending Nicole in this frivolous action. We have an opportunity now to respond to the NEA's motion for a preliminary injunction, and we have some very worthwhile and I think productive paths available to us to quickly dispose of this lawsuit and ultimately to get the records at issue. Let's see here.
Before we go to the next question, John, I want to talk a little bit about some of the cases that are on the horizon, possibly. And that is two cases where Justice Thomas particularly said that the court should take questions that it has not taken in the past. And, the court takes very few cases. And a lot of the time, that means it's passing up issues that really it needs to resolve. And I thought there were two really interesting dissents from denial of certiorari when the court said it's not going to take a case, and one of the justices said we ought to, and that particularly Justice Thomas. The two that I thought were most interesting was a case called Berisha versus Lawson, in which Justice Thomas and also Justice Gorsuch complained that the court did not take that case because they think that the court should take it to resolve a very important First Amendment question, and that is particularly the issue of New York Times versus Sullivan, and when can a public figure sue for defamation? When, say, you're the mayor of your town, when the newspaper prints a scurrilous or a fraudulent story about him, can he sue for libel? And under the case of New York Times versus Sullivan from the 1960s, typically a public figure is not allowed to sue. They have to meet a very high threshold, so high that public figures typically can't sue. Who's a public figure? Well, it started out being like obvious, government officials, but it's grown over time to mean people who are pervasively famous, right? Well, what does pervasively famous mean in a world where everybody's got an Instagram account, everybody's got a Facebook account, everybody's on Twitter, everybody's on whatever? That issue has become a lot more problematic. And I think Justice Gorsuch in particular has an interesting opinion here. Justice Thomas, his view, of course, being an originalist, he says there's no basis for this whole New York Times versus Sullivan standard for public officials in the history of the First Amendment. Justice Gorsuch, he adds, he says, the Sullivan rule is bad for democracy. It tends to make public officials or make citizens afraid to run for office because it means that they're going to lose their protections against libel. And isn't everybody famous now? Those are really interesting questions that the court, I think, is going to have to address at some point. The second case that I thought was an interesting denial is this case called Standing Akimbo, which is a case about the restrictions on the use of marijuana. Remember, years ago, the Supreme Court said that Congress could outlaw marijuana under the Commerce Clause. Well, Justice Thomas points out in this opinion that now so many states have legalized marijuana in one form or another that you have a crazy patchwork of law that nobody knows what is and isn't allowed. And so it no longer really makes sense to say that that Congress can regulate it under the Commerce Clause if it's no longer really an issue of national concern. So those are definitely interesting opinions I commend to your reading.
Let's see here. Interesting question. What would you think of Arizona legislation which mirrors federal deprivation of civil rights at the state level so that infringements could be handled, making a federal case out of certain state actions, something like a Bivens action at the state level? Tim, I know that's near and dear to your heart.
Absolutely. In fact, I've tinkered with a draft of something along these lines myself. I think that Arizona needs a civil rights conspiracy statute. If you look up in federal law, there's a law called the Civil Rights Conspiracy Act, also known as the Ku Klux Klan Act, that was passed in the 1870s. That prohibits not only the violation of your civil rights, but conspiracies between public and private individuals to deprive you of your civil rights. So, for example, if a group of people gets together and comes up with a way to bushwhack you on the way to the polling place in order to prevent you from voting, that's a conspiracy to violate your civil rights. No such statute exists at the state level in most states, although maybe you could make an argument that that still violates existing state law, but there are very few states that have an actual statute on this. I think Arizona and other states ought to adopt one, but there is none right now.
Another good question. SCOTUS continues to not take cases related to qualified immunity, although there's been some very interesting opinions on the denial of cert on this question. Do you have any comments you can share? Why don't you go ahead and take that?
So that is true. The court has been not addressing this issue. I think this is one of those issues on which I think you will find the court at the most conservative. I don't mean politically conservative, I mean temperamentally conservative. The least likely to change its existing precedent is in this area of immunity for particularly for police officers. Qualified immunity is this rule that says you can't sue a police officer for doing certain things unless the officer knew that it was illegal. The problem is knowing it was illegal is read very narrowly. Like if you beat up somebody on a Monday and the court says that was illegal, that doesn't mean you can't beat the person up on Tuesday. I mean, it's really that ridiculous, the way that some of these cases have read. There are some cases that are going forward, a couple cert petitions actually that we know are going to be filed soon that we'll be supporting as amicus on these kinds of issues. And eventually the court is going to have to take it. I think it's ironic, Justice Thomas says in this one dissent, there's no basis for New York Times versus Sullivan in the Constitution. Well, find me the basis for qualified immunity in the Constitution. There's no basis for that. It was a judge-invented doctrine that had good intentions in the sense that it was intended to protect public officials from being sued for frivolous things. Unfortunately, it's been abused so thoroughly that it's now being used as a device for violating people's rights, even in the most extreme circumstances imaginable. We'll have more to say on that in the coming months.
All right, we got time for one last question. This is a state constitutional question out of Arizona's state constitution, which we always love. Article 2, Section 2 says that the purpose of government is all power is inherent to the people and that government derives its just powers from the consent of the governed. Is there any room for movement for that particular state constitutional provision, or perhaps maybe some general state-based litigation?
Well, I know that's a favorite clause of the Constitution for you, John. What do you think?
Yeah, I mean, look, here's the thing with state constitutions. We advocate for this across the board. They're really, really wonderful tools that can be used to protect and advance liberty. State constitutions do that in two ways. The first, where there's analogous provisions, so free speech protections, equal rights protections, due process protections, et cetera, where they also exist in the federal constitution. State courts are not bound by federal precedent. That's just a floor to the protection of those rights. State courts can go above and beyond in protecting individual liberty when they're interpreting their own state constitutions. And then additionally, state constitutions include a whole host of provisions like this one that don't have any direct analog in the federal constitution. And we've done an awful lot of litigation along those lines, most recently and perhaps most notably using state constitutions, anti-subsidy provisions or gift clause, which prohibit corporate cronyism, prohibit gifting public funds for private activities. And frankly, it's just an opportunity to really develop an entire body of law that a lot of litigants don't ever really explore in their cases. So I think there is, Charles, a lot of opportunities with that particular provision, as well as many others in our state constitution and every state constitution. Any closing remarks, Tim?
Thanks, everybody, for joining us on our annual Supreme Court Roundup. With the Supreme Court will begin its next session in October of this year, in just a couple months, and then it will be time to do one of these again in next summer. It's hard to believe that it's already August of 2021. But anyway, thank you all for joining us. And remember, if you want to support our work, it's goldwaterinstitute.org. Keep an eye on the work that we're doing across the country at our blog at indefenseofliberty.blog. And we'll see you all again.
Thanks so much. Have a great day, everyone.